Okay, now we are coming out of recess. Okay, council members, if it's okay with all of you, I think we have another really important agenda item, referrals for executive session. I think the public has waited long enough for this one as well. So if it's okay, I'd like to read in both executive session items so that we can discuss them at the same time. Mr. Clerk, Communication 9.1 and Communication 80.
Referrals for executive session, Communication 9.1. Special counsel request for appeal of Hawaii Floriculture and Nursery Association et al. Versus County of Hawaii, civil number 14-00267 BMK, Federal District Court, the District of Hawaii, to the United States Court of Appeals for the Ninth Circuit, case number 14-17538, from Deputy Corporation Counsel Catherine A. Garson, dated January 15, 2015, requesting an attorney-client confidential discussion to consult with the counsel regarding the above entitled matter, including a request for special counsel with approval of payment of costs not to exceed $10,000. Communication 80, claim regarding Makana Fernandez minor from Deputy Corporation Counsel Christopher P. Schuler, dated January 14, 2015, requesting an attorney-client confidential discussion to consult with the counsel on a personal injury accident occurring on January 2nd, 2013.
Thank you, Mr. Clerk. Ms. Ia.
Mr. Chair, I move to convene an executive session regarding Communications 9.1 and Communication 80 pursuant to Section 92-5, parentheses A, parentheses 4, for the purpose of consulting with our attorney on questions and issues pertaining to the council's powers, duties, privileges, immunities, and liabilities.
May I have a second?
Second.
It's been moved by Ms. Eoff and seconded by Ms. David to go into executive session. Mr. Chung.
Yeah, again, I'm going to have to vote against this executive session. It looks like, based on the testimony that we heard today, everybody knows what this thing is all about. You know, all of the parties, I mean the different, the proposals. They even talked about the cost today. That was kind of strange. I don't know how all that information got out. But nonetheless, I really don't see a need for an executive session. If something comes up, then we can go into an executive session. But I think it's just a matter of saying yay or nay on this, in my opinion.
Mr. Iligan.
I'm going to respect my ally in the council, and I'm also going to go against this executive session.
Okay, thank you. Okay, I see where this might go, but maybe we should read in, we should just have the motion for executive session, read it in separate, say the motion separately for both communications. So if you want to withdraw your original.
Okay, I'll withdraw that motion.
And then we'll just start with communication 9.1.
Okay, move to convene an executive session regarding Communication 9.1. Second.
Okay, it's been moved by Ms. Eoff and seconded by Ms. David. And we've heard Mr. Chung and Mr. Iligan speak about this. Is there any other discussion? Council members, Ms. Poindexter, to go into executive session.
Could I ask Ms. Garson if we can discuss this in open?
Yep.
Deputy Corporation Counsel Catherine Garson. I think there are some things that you can speak about in open, but it does depend on the questions that arise. And so if you ask for my legal opinion or my legal analysis, then I would request that you do go into executive session for that. So, but there are some things that you can discuss that in open session.
I guess I was wondering, just because if it's listed under executive session items, can we begin a discussion, or would I have to withdraw that motion, and then can we actually discuss the item outside? In public.
You want to start in public, and then when you start asking something that goes beyond what we can discuss in public, then move for executive session? I think that you can.
So should I withdraw that motion at this time?
Sure, because you think that if it's not, then you won't be able to move in when you need to. Is that correct?
No, it's just that the motion on the floor is to go into executive session, so we'd have to vote on the...
Let me just make sure this is consistent with the advice that you've been given thus far. Okay, hold on.
Okay.
Yeah, you can go ahead and start in open, and then if something comes up a question that I'm uncomfortable answering
Oh, so it's
in
okay to
public,
leave the motion on the floor and then...
you can withdraw it, and we can start
Oh.
in open if you would like to do that.
Okay, then I'll withdraw the motion at this time.
Okay, thank you. The motion's been withdrawn, so I think we're gonna have to have another motion so that we can discuss this.
I move to open discussion on communication 9.1.
Is that a proper motion? I don't think that's a proper motion.
Or move this out of referrals for executive session.
Yeah. I think the motion is going to have to be, can I have a motion to approve special counsel, to hire
So
special
moved.
counsel?
So moved.
Second.
Okay, it's been moved by Ms. Willie and seconded by Ms. Poindexter. Discussion,
Yeah.
Ms. Willie.
Okay. Okay, I think this should be a no-brainer. I think that this is, even for those who have questions in terms of the GMO, this is about our authority as a county and would be, the opinion is very broad. I also think, in terms of if this, what are the consequences? We go forward, we hire expert assistants, we're trying to win. If by voting against it, I see it as wanting to decrease the likelihood that we're going to win on this, which to me is, following those consequences, is sort of afraid, what does it mean for those who, support a lot of the biotech operations? And I just want to address that fear for a moment. I actually go back, I think that Mr. Paleca's statement about case by case was pertinent to this. And as I see it, it isn't just black and white issues. We do have exceptions and grandfathers, and we also were going to move forward. I think one point I think is relevant, and that is such as the floral industry that some of the representatives came here to testify. Actually, I agree, and Corporation Counsel agreed and represented to the court that what they're doing, their GMO operations in the greenhouses, is not contrary to the bill. So it isn't all black and white, and that if the law is upheld, we aren't at the end of the line, and there's more to do. So again, I just certainly hope that council members don't want to relinquish their sort of the importance of county governance. There are no cities, there are no towns here. We are the county's the first layer of government, has been stressed, the importance of that local government. And what I always say is, you're not going to put an ocean between the people and the first layer of government. And that's really what this is all about. And with the bill that we have here, contrary to some, even the Kauai bill, is focused on property and land use, which is the area that's most close to sort of a local government and jurisdiction. And I do think that we have, it's a challenging case, really, because the law is so complex. And even though the focus on this is preemption, the whole issue ties together with complex administrative law, contract law, such as through permits, and patent law, and how all of these things overlap. And as I think Ms. Garson or I talking is just getting used to all of these numbers. Ms. Bronster, this is what she does. This is all she does. I mean, she has a high level of expertise. So do you want to send somebody in, as great as Kathy is, and wonderful, with many other responsibilities, where she could have someone pro bono coming in and here helping? So really, I think it's important to take it out of are you pro-GMO or pro-GMO and stand up for our own self-governance and the importance of this body that we're a part of, unless you just want to move on to state government, but I think that that's where it is, and I think it's important to not just say, oh, this is just, I'm for GMO or I'm on that, and just support. I think it should be a no-brainer. I guess that's where I stand. And I hope that you all will support this, and we can move on.
Thank you, Ms. Willie. I know Mr. Chung had his light on in the beginning. Oh, no? Okay. Oh, did you want to go? Mr. Onishi.
Okay, Kathy Carson, can you please come up?
Once again, Kathy Garson, Deputy Corporation Counsel, and Larry Martin's our litigation supervisor and assistant corp counsel.
I've never really been involved in like appealing a decision and so forth. So, and I need information on, okay, so the federal judge ruled, he made a decision, and so the appeal is on his decision, or like what Ms. Willie's mentioned about patent rights and all this land use and all this kind of stuff. Because what I understand is they only can argue on what was the decision, right? There's nothing new that you can bring in. Is that correct?
Basically, you can't bring any new argument in. It's what you argued below. So what you authorized was the appeal of the court's decision, and so that's what we argued, that the decision was incorrect.
So
for the same reasons that we argued below that it shouldn't have been entered as an order to begin with.
Okay, so whatever you had argued in the defense for Hawaii County.
Correct.
Okay, the judge didn't feel that you had proven enough burden of proof, or what happened? I mean,
it was a motion for summary judgment, so he felt that the law, that there was no genuine issue of fact, and that the law supported his decision to find that it was state preempted and partially federal preempted. And that's what we're appealing. And just so you know, the plaintiffs cross-appealed.
to what?
So they're appealing also the judge's decision that he was wrong in not granting all the relief that they asked.
Okay, so that part is new. Will that be part of their arguments when they go to court, or that's a separate issue?
The appeal and the cross-appeal are it's
Separate issues? Or it's all same one?
it becomes all of the same appeal.
So then they have to prepare for both sides, for two different arguments.
Oh, wait, explain this better.
Basically, it's just adding another issue for the Ninth Circuit to decide.
So
But really, all of the issues are combined. So the county moved for summary judgment, the plaintiff moved for summary judgment. So it's really the same issues that are coming up in both of the decisions.
Okay, so to my understanding, so they won't be bringing anything new to the table.
Generally, that's the rule. Sometimes people will try and make new arguments, but generally the rule is if you did not argue it below, then it's waived.
Okay. And then so if that's the case, then why can't Corp Counsel still represent us?
It's not a matter of can't represent you. It's that both our Justice and Center for Food Safety have expertise in this area. They have litigated these cases involving GMO, cases involving the Plant Protection Act. They have litigated in the Ninth Circuit.
Okay, wait, no.
Yeah.
So was there anything about Protection Act in this judgment?
Was there a what?
Anything about Protection Act?
The plant protection, yeah. Yes.
Yeah, there was a
Yes.
judgment.
Yes.
Okay.
I'm just saying, they have the expertise in the area of GMO, and they have argued cases in the Ninth Circuit.
But I understand-
Cases that we've relied on. This
then-
is what they do, similar to that's what Ms. Bronster does.
So have they were they like at that first level, like how you went to federal court and
Yes.
then they lost, or they appealed, or have they like jumped into different
They're involved already in the Kauai case, and that appeal is pending. In this case, they were allowed to argue during the motion for summary judgment. They weren't a party, but the judge allowed them to argue.
On behalf of the Hawaii County?
On behalf of other clients.
Like who?
Clients. Center for Food Safety, and then 3 other individuals, Nancy Redfeather and 2 other individuals. But that was like a friend of the court brief. Sometimes they allow people who have certain expertise to file briefs to help the judge make a decision. And Center for Food Safety and Earth Justice were allowed to do that. So they too were part of that argument at the lower court, and they assisted greatly.
So why can't they just move forward on their own?
Because they weren't a party. They were just a friend of the court.
But they're part of a party.
No, they were not allowed intervener status in our case. So it was only.
But they could give briefs.
They could brief and they could argue because the judge let them. And that is not a guarantee in any way at the Ninth Circuit.
But then, so they got to argue, but then the judge still ruled against them.
Against us.
Well, yeah,
yes.
but they gave briefs, right?
Correct.
Right, and so they're like trying to convince the judge that he should not, I guess, favor plaintiff.
Right. We argued for the validity of the bill that you passed.
Right.
So we were on the same side. We argued that it was valid.
No, yeah, right. That's what I'm just saying, yeah. That's what I said earlier, but.
Yeah.
Okay. Okay, thank you.
Thank you, Mr. Onishi. Ms. Yoff.
Thank you, Mr. Chair. Hire special counsel, and although not all of us supported a prior motion to appeal this, I would urge, though, that all of us do support hiring special counsel, because now that we are engaged, I think we should do the very best that we can and with the expertise that is offered, especially because we have the, well, let's see, let me go back a little bit. I think it was 2008, actually, Ms. David and I both, we worked with the Councilman Pelago to introduce the protection of taro and coffee and to ban the GMO experimentation with taro and coffee. So I've been concerned that we need the best that we can get to protect that part of our code, because that is not only important financially, but culturally to many, many people here on the island. So I'm supporting hiring a special counsel, and I would hope that most of us will do that so that we can go forward.
Thank you, Ms. Yoff. Ms. David.
Yes, hi. I do support the hiring of counsel. I realize that when you have a very contentious and complicated issue like this, you just don't stop because one judge says you're wrong. If you believe this, and I think the testifiers today express that, and for me, having to do that kind of work, writing friends of the court briefs, it's hard work, and you've been given a gift by Earth Justice when they offered to pay for this litigation. And this is not the end, because I know that there are several levels of litigation before it's the end. So I support this 100% and hope my colleagues do the same. Mahalo.
Thank you, Ms. David. Ms. Poindexter.
Yeah, I was kind of like a little offended by Bronster coming here and trying to give us legal advice. You know, I have a lot of respect for Earth Justice, because when they sent the letter, they sent it to our attorneys, which is Corp Counsel. They did the right thing. Ms. Bronster and their law firm addressed us as counsel, not only here, but in a formal letter, twice. You know, in response to a letter that Earth Justice did to our attorneys. So like them, we don't go and address their clients, yet to me that was very disrespectful of them. And they're desperate right now. Why? something doesn't smell right here. And here, some of the statements that they alluded to that they cannot, Earth Justice cannot, or shouldn't represent us. They've represented another municipality, I think it was New York. So they have, and when I go to court, if I have a criminal case against me, I'm not going to a family court lawyer to go ask them to represent me, So with no disrespect for you, you're a great attorney, but that's not your expertise. So I agree that we should definitely, and I'm supporting this, that we need to. And what harm will it do? It's going to be either a yay or a nay. So nobody, that's the decision. The court in the last vote came that the majority said, hey, let's start this. So now we have this opportunity to do it with the experts. Why not? Why not? We're not going to pay anything else extra. We're going to pay what we're paying. So it is, like Councilmember Willie said, it's a no-brainer. So thank you. I'm supporting this.
Thank you, Mr. Paleka.
Thank you, Chair. I really have a problem with this, and it's because of the conflict of interest, I think. I know a lot of testimony and the views of my fellow colleagues is that there is no conflict. But then I have to come up again with another analogy in my head. If we were to, hypothetical, pass a firearms ordinance, would we then be asking the NRA to come to our rescue or come and help us litigate because we lost? Would we do that? It is the same thing. It is.
Mr. Chair, point of order.
Yeah.
Ms. Poindexter, you cannot be making face comments when...
Well,
No. Hold on. Thank you.
Okay, but, she got to control herself, and then,
I'm not.
No, but...
Thank you for your point. Yeah, we just need to keep the comments so that nobody can hear them. Keep them to yourself, and we'll go.
I don't mind, not a problem.
Mr.
But
Paleka.
I'm just trying to make that point, and I'm an organic farmer myself, but I have a real difficult time with this issue because I think it opens the door. And, I'll just leave it at that. Thank you.
Thank you, Mr. Paleka. Before I get to Mr. Onishi, I just want to make sure everybody has a first round to talk.
Can't to you guys again. So if we lose appeal, what happens next?
You can appeal to the United States Supreme Court.
So we just continue going on?
You can.
Because
Because...
we're free counsel, that's why.
No,
What? That's the bottom
no, I said,
line.
I mean,
No, it's the bottom line.
you can. You could also choose not to.
No, but yeah.
You
But
know.
that's the bottom line. That's what you were here right now.
Right, and you already decided to appeal.
Right.
Yeah, and so we're already going forward. I filed a notice of appeal. We have a cross appeal against us. I
And
mean,
so-
so we're already there.
Right.
Yeah.
And then so if we lose appeal, then we're just gonna move forward.
If you lose the appeal, then I might come back and ask you to take it one step
But then
further.
you could also be corp counsel, just tell us, okay, that's it.
It's your decision as a client. And you're the client.
But then, as Mr. Chung had mentioned earlier about, like the testimony that we had gotten, I mean, the information that they had given, I mean, it's like, just like it was a slam dunk deal that everybody knew of what was going to happen or who was involved, the parties that were involved. I mean, I know it was in the papers, and it kind of mentioned, I think,
I think Mr.
was there money mentioned in the papers, like the amount that we're going to be spending?
What, the 10,000?
10,000 was 100,000 or 10,000, wasn't it?
No, it's only 10, and I asked for that in my open letter for costs. And Mr. Achitoff made the offer to represent the county for free in open
just
session when you guys are voting on the appeal.
No, but just
So
recently. Just recently, weren't there an article just recently in the papers? No.
Like in the last couple of days that you were
Yeah.
going to take this up today?
Yeah.
Yes.
And
But that
wasn't one amount-
information was public already.
But wasn't there an amount that was mentioned in the papers in that article?
If anything, if it was an amount that we gave, it would have been this 10,000 for cost. And I put that in there, not knowing whether or not we would be asked to reimburse costs or not.
Okay. Okay. So if we do lose the appeal, then we're looking at moving forwards.
We're getting into hypotheticals.
I know what okay.
Thanks, Mr. Onishi.
From them. I recall at the meeting we had when we decided on whether to go appeal, they did offer on the floor. But did they follow up with a letter to the Corporation Council?
Yes.
Okay. After the decision to appeal?
Yes.
Thank you.
Any other discussion? Mr. Chung?
Again, maybe this is something that Fresh asked, but, so when you guys go on appeal to the Ninth Circuit, right? The Ninth Circuit Court of Appeals, you guys will be limited to the arguments that were made at the lower court?
Generally, yes. Like no new evidence, right? You're not going to file new
Right.
affidavits. You're not going to file,
Right.
you know.
It's just arguing with what you have there, right?
Correct.
Okay. And,
And that brings up a good point. But let's say we do go to Supreme Court. People hire attorneys who have the kind of expertise in front of the U.S. Supreme Court just to argue in front of the Supreme Court. I mean, I guess I kind of feel like we're at that stage. These attorneys are very familiar with the issues, not only because of their work in Kauai, but their work in this case, and they've argued extensively cases in front of the Ninth Circuit. So.
in order to get special counsel, what kind of vote do you need on this board?
It's a 2/3.
What?
2/3. 6.
Okay.
Thank you, Mr. Chung. Mr. Ilagan?
Thank you, Mr. Chair. I don't think I can say anything that's not already been said. And regarding the merits of this bill, you know that why is there even an exemption? Why is there even an emergency provision to put up GMO? So everyone knows that I support GMO, and I can't vote to support the special counsel. I looked at Earth Justice, and I respect their environmental principles, and I like the fact that they fought to preserve the salmons on the west side, the eastern side of the western side of the United States, and you know, I'm glad that you guys are looking into this and looking for options. I just can't support your option, and I appreciate all the hard work you do. Good luck, and Godspeed.
Thank you, Mr. Ilagan. Any other discussion, council members? Okay, Mr. Chung, apologize.
What is the motion, anyway, to approve? Okay.
Right.
Then I'll just tell you my feelings on all of this. First of all, you know, there may be some conflict issues, possibly, I don't know. But I think it's really not for us to decide. Mm-hmm. Yeah, it would be incumbent upon maybe Ms. Bronster to bring them up with the court and see what happens. So this is how I look at it. You guys know I'm against this ordinance, right? I stand committed to trying to find, more, some kind of ordinance that would allow both sides to coexist. I don't know if possible. I really don't know, but I shall continue to do that. This issue has driven a wedge through our community. Unfortunately, we talk about compromise. I know there were some compromises made when I was reading the newspaper, but there's still some people who are put off by all of this. But this is how I look at this issue. The appeal has already been approved, right? I was on the losing end of that one, 5-4. It's either you guys, Earth Justice, or somebody else, right? Earth Justice is offering to do this thing for free. If they take on the matter, and I'm going to hold them to doing it for free, then it frees you guys up to do other things. So we got opportunity costs over there, right? What I'm really concerned about is if you guys take this thing on, we're putting you guys in a real untenable situation. Because if you guys lose, you guys are going to be criticized. We're going to be criticized. Yeah. Although I really believe, though, Kathy, you guys can do a really good job on this appeal. As good as Earth Justice, probably, because it's just a review before the Ninth Circuit Court of Appeals. But having said all of that, I'm going to be supporting this request. Okay, I think it's the best way to go, quite frankly. And I'm still against the ordinance, but I just don't want to put you guys in a bad position.
Thank you.
Thank you, Mr. Chung. Seeing no other discussion, I'll end discussion and just say, it seemed pretty simple to me. You guys have a lot. Mr. Chung couldn't have explained it any better, so I'm not going to repeat all of that. But either we have help with Earth Justice representing, or we have Corporation Counsel doing it all. And I'll take the help any way we can. So that was, the appeal's already going to happen. So it just makes sense, in my opinion. Okay, thank you. Mr. Clerk, on the motion.
Regarding Communication 9.1, motion to appoint special counsel, Mr. Chung.
Aye.
Ms. David.
Aye.
Ms. Yaw.
Aye.
Mr. Ligon.
No.
Mr. Onishi.
No.
Mr. Paleka.
No.
Ms. Poindexter.
Aye.
Ms. Willie.
Aye.
Chair Kanuha.
Aye.
Chair Kanuha, you have 6 ayes and 3 noes.
Thank you. Motion passes. Thank you.
Thank you.
Thank you, Kathy. Okay, now we'll move on to Communication 80. Miss Yoff.